the recent decision in Pharmaceutical Care Management Association v. Mulready is a big lawsuit that addresses ERISA and Part D preemption. So PCMA, which is the trade association that represents PBMs, challenged a 2019 law in Oklahoma that sought to regulate PBMs. And so there were 4 provisions that they challenged in this law. Those are briefly a requirement that network adequacy determinations were only using retail pharmacies, so they were prohibited from using mail order pharmacies in determining adequacy. There was a prohibition against the use of cost sharing or copay discounts that would incentivize patients to go to affiliated pharmacies, which are pharmacies that are owned by the PBM. And then there was also a requirement for PBMs to admit any provider that was willing to meet their terms into the preferred pharmacy network. And this is something that's commonly referred to as any willing provider legislation. And then lastly, there was a prohibition against PBMs removing a pharmacy from its preferred network or refusing to admit a pharmacy into its preferred network on the basis that a pharmacist at that pharmacy had their license placed on probationary status or revoked or received some other disciplinary measure. And in this case, the 10th Circuit found that all 4 provisions of the 2019 law were preempted by ERISA, and the any willing provider provision was also preempted by Part D. And this is a big deal for employer-sponsored benefits because had the court decided against PCMA and for Oklahoma, it would have really opened the floodgates on state ability to regulate PBMs. And so we would have seen a huge amount of variety, probably very quickly, between states. And so those PBMs and health plans that do business across state lines would have had to completely overhaul their compliance practices and departments in order to manage all of these different, possibly conflicting state requirements. This is in the context of a Supreme Court decision from a couple of years ago, Rutledge v. PCMA, which also dealt with ERISA, but it expanded state ability to regulate PBMs. In this case, the court was very careful, the 10th Circuit was very careful to articulate that their decision was consistent with the Supreme Court's precedent in Rutledge. And so this is not contrary to the Supreme Court, according to the 10th Circuit, and hopefully will continue to be a part of the Rutledge landscape moving forward. But the big question that remains now is whether the Supreme Court will take up this case. So at this point, Oklahoma has not appealed the 10th Circuit's decision, but we expect them to. And so it's not clear whether the Supreme Court will decide to hear the case or if they think that the 10th Circuit got it right. If they were to take the case, then we're looking again at that possible opening of the floodgates that would lead to instability for ERISA and Part D plans. I think an interesting policy that hasn't gotten a ton of attention is California's state-manufactured generic drugs. So this is part of a law that they passed several years ago, and the program is called CalRx, and they announced earlier this year that the first drug manufactured under this arrangement would be insulin, and it's capped at $30 for a month's supply. This is a first in the nation kind of law. No one else is doing this. And I think it's the kind of law, it's the kind of program that we could see other states, particularly those states that are held by Democrats, emulate in the future. So I could very easily see Illinois or New York adopting a similar program if California has good results in keeping insulin costs down, whatever drugs they may decide to manufacture in the future. So I think that's a really interesting one. The results probably won't be immediately apparent, so it'll take years to see how this plays out. But it's something that I'll definitely be keeping an eye on as it develops over the next couple of years, and I think other folks in the pharmacy care world should be paying attention as well.